We have studied the duties of the trustees and liabilities of the trustees. Today in this lecture, we will see the rights of the trustees. Section 32 of the Trusts Ordinance provides that a trustee is entitled to have in his possession the instrument of trust and all the documents of title relating to trust property. Always the trustee must have the deed of trust and the deed of transfer. As we have studied in our express trust, the trustee must execute the deed of trust, plus the property should be transferred to the trustee. Therefore, there may be two documents. One is deed of trust or instrument of trust, other one is deed of transfer. Once the trustee is appointed, he accepts the office of the trustees. Upon the acceptance of the office of the trustee, the rights accrues to him to take into his possession and custody the instrument of trust and all the deeds, especially title deeds, in relation to the trust property. Taking custody of instrument of trust is necessary for the trustee to ascertain what is transferred by the author of the trust to the trust, and that will enable him to know the directions and the purpose of the trust. It is absolutely necessary to discharge his duties as trustee strictly under the instrument of trust. Similarly, the title deeds, that is the deed of trust related to the trust property, will give him an idea of the nature and extent of the trust. Custody of the title deeds will enable him to decide as to whether any suit is required to be filed for the protection and recovery of trust property if it is in the possession of trespasser or other person who is not entitled to have such property. It may be also necessary to defend any suit relating to trust property. If the title deeds are in the possession of some other person, the trustee shall take appropriate actions or the steps to recover them from such person. He has to keep such title deeds in the proper custody. If they are lost due to the negligence or whatever, then he shall be liable. Then from this section, this is another important right given to the trustees to take custody of these deed of trust and the deed of transfer. Then we will move to other sections 33 of this trust ordinance. Subsection 1, every trustee may reimburse himself or pay or discharge out of the trust property all the expenses properly incurred in or about the execution of trust, realization, reservation and benefit of the trust property, or the protection or support of the beneficiary. Then simply we can say under this section, trustee may reimburse whatever expenses incurred in connection with the trust property. If the trustee pays such expenses out of his pocket, then he has a charge upon the trust property for such expenses whatever incurred. But such charge shall be enforced only by prohibiting any disposition of the trust property without previous payment of such expenses. The first subsection 1 provides that trustee is entitled for reimbursement of any expenses incurred by him in the execution of trust. Subsection 2, if such expenses paid out of trustees, out of his pocket, that's the trustee has, if the trustee paid out of his pocket, then he has some sort of charge on the trust property. And also, that means, what is the charge? In the sense that is a lien that we will see later. Then if the property fails, now there's a charge on the property, then first of all he can recover that money from the trust property or trust fund. If the trust property fails, then what? The trustee is entitled to recover from the beneficiary personally on whose benefit or whose behalf he acted, or at whose request expressed or implied he made such payment, the amount of such expenses. Then the fourth one, that also reimbursement but in a different way, where the trustee has paid, where the trustee made overpayment, paid more to the beneficiary, then he may reimburse such money from the trust property. If the interest fails, then the trustee is entitled to recover from the beneficiary personally the amount of such overpayment. By mistake or something, paid little bit more. Then when you see this section, what we understand that generally speaking, the trustee is not entitled for any remuneration. But it doesn't mean that the deed of trust should not provide any remuneration to the trustee. There is no bar at all, but as an entitlement, as a right, trustee is not entitled for remuneration. But here, he is entitled to the reimbursement for his out-of-pocket expenses incurred by him for such management. It is in the nature of the office of the trustees, whether expressed in the instrument of trust or not, that the trust property shall reimburse him of the charges and expenses incurred by him in connection with the execution of trust. When the matter of reimbursement reaches the court, it is generally reimburses or indemnities the trustees of all expenses made by him from his own pocket for the due execution of trust. That's why under section 33 of the Trust Ordinance entitles the trustee to be reimbursed of the expenses incurred by him for protecting the trust and trust property. If he fails to recover it from the trust, then from the beneficiary, when the trustee acted in bona fide. So the trustee defending the trust cannot be expected to spend money from out of his own pocket, but has a right to reimburse the same from the trust fund. The court should allow in favor of trustee the expenses he had incurred in respect of trust provided they are incurred in good faith, even though that expense could have been avoided if the trustees has exercised due care and attention. Every trustee is entitled to reimburse himself out of the trust property, or if it fails, from the beneficiaries personally whose benefit or behalf he acted, for the proper reimbursement properly incurred in the exercise of trust or the interest thereon. The expenses relating to or incidental to the management of the trust has to be reimbursed from the trust fund. When the trust included a farm overgrown with the trees and passerby is injured, then the trustee had to pay the damages to such person for his injury. The trustee is entitled to reimbursement of such compensation paid as an item to the incidental expenses for the management of the trust. What we are seeing here, if it is incidental to or relating to the management, say suppose there is a farm, then the trees are there, the passerby in that area injured because of the trees or whatever it is, then the trustee has to pay the damages, then the damages may be reimbursed from the trust fund. Similarly, when a trustee has been working in a firm or something, in a place where if anything damage occurred to him, then he can get those expenses from the trust fund. When a trustee has to appoint a lawyer or attorney at law for instituting actions for recovery of monies due to the trust, the cost incurred as attorney at laws or lawyer's fee, etc., may be reimbursed from the trust. Similarly, where employment of attorney at law becomes necessary for the trustee to appoint attorney at law or the agent for a better conduct of affairs of the trust, and without such employment, it shall become difficult for the trustee to administer the trust. The trustee will be entitled to the cost incurred by them for appointing a lawyer or the attorney at law for the betterment or the better management of the trust. It is evident that the right to reimbursement is available only in respect of expenses which are properly incurred. When you see these expenses, the expenses include damages and cost awarded to third party in proceedings against the trustee as a owner of the property, the liability incurred in carrying on business if so authorized by the instrument of trust, call on shares, payment of statutory allowed whatever claims despite of opposition by beneficiaries, cost of appointment of new trustees, premiums on insurance policy to preserve the trust property, cost of defending the actions on behalf of the trust irrespective of results, but not excessive or unnecessary cost. Then generally speaking, the expenses limited or include all these things, but should not be excessive and unnecessary cost. It is fit and proper that for the prosecuting a litigation for on behalf of the trustee should seek the leave of the court. That's the good idea at all. Always, before go for a prosecution or litigation, first of all get an opinion, leave from the court. If he he initiates such an action without a leave, he has to satisfy that the costs have been properly incurred for the benefit of trust, even if he acted on the advice of his attorney-at-law counsel. The test in such a case would be whether the court would have authorized such action if the prayer for sanction has been asked for. In such a case, the court, on being satisfied that bona fide nature of the action, may in its discretion allow such costs to be reimbursed by the trustees. Then we will see the lien part. Trustees lien. What is known as lien? That's, of course, you will study in your commercial law, the shipping laws. Lien means a right by which a person in possession of the property holds and retains it against the others in satisfaction of demand due to the party retaining it. Or otherwise we can define another way, lien is also a right which a person to whom a sum of money is owed by the another is given in law of the goods of that other to secure the payment of sum owed. The trustee's right of reimbursement of expenses properly incurred constitutes a lien on the trust. When a trustee borrowed money on the account of the trust and had used it for the benefit of the trust, he would be entitled to indemnify himself from the trust fund. But the trustee or his legal representative can sue for indemnity against the estate only on showing that the amount spent for the private fund of the trustees was for the benefit of trusts. It is then the trustee shall have the lien of the trust for such expenses. When such a lien is there for the trustees to enforce against the trust, the beneficiary cannot compel the trustee a conveyance of trust property in his favor as per terms of these deed of trust, without satisfying any claim for reimbursement which a trustee may have against the trust, as trustee's lien for expenses is the first charge on income. Lien is available only when the trustee incurs expenses acting within the power of the trust, but no such lien can be claimed when the trustee acted beyond the power of the trust and thus commits a breach of trust. That's why when the trustee entered into the transaction which was unauthorized, even if the beneficiary concurred for such transaction, the right of indemnity would not be available to the trustee with a lien over the trust. A trustee has no personal remedy for the expenses incurred by him against the author of the trust, because there's a lien attached to the trust property. He was to look to the trust fund for such purpose primarily. He can see a remedy against the beneficiary on whose behalf or at whose instant he has acted or made such expenses. But the personal remedies will be available against the beneficiary who are sui juris. Personal remedies against the beneficiary may lie in any of the four classes of cases, namely, the first one, when the trustee has accepted the trust at the request of the beneficiaries. When the beneficiary is himself author of the trust, second one. Third one, where the beneficiary is the sole beneficiary sui juris and entitled absolutely. All the beneficiaries are sui juris and have collective interest, and the trustee had acted at their joint request. These are the 4 cases, class of cases where the lien may arise. Then we have seen in subsection 4 what is known as overpayment. Overpayment may arise due to the inadvertence or on the doubtful construction of the terms of the trust deed. When the trustee made overpayment to the beneficiary on his own erroneous construction of the will, he was held to have a lien to such overpayment from such other interest. Overpayment may be arise for the failure to deduct income tax when the payment is made to the legatee. In all such cases, trustee has been held to have a right to reimbursement from the interest of the beneficiary. This is in relation to the overpayment. Now we will see the next section. Section 34. Section 34, a person other than a trustee. A person other than a trustee or the transferee, in good faith for the consideration, who has gained an advantage from the breach of trust, must indemnify the trustee to the extent of the amount that they have received under breach of trust. Where such person is a beneficiary, then the trustee has a charge on his interest. That's a lien that we have seen. Nothing in the section shall be deemed to entitle a trustee to be indemnified, whereas in committing breach of trust, being guilty of fraud. Section 34 enables a trustee a right to indemnify from the gain of the breach of trust, because the loss to the trust shall be cast on a person who has gained such advantage from the breach of trust. If the person who reaps the gain from the breach of trust is beneficiary, then the trustee will have a charge on his interest for the recovery of advantage so gained by the beneficiary. This principle shall not apply when the trustee committing a breach of trust is not guilty of innocent breach, but of the fraudulent breach. It is clear that when the trustee reaps benefit of a breach of trust by him, he is liable to reimburse. But if a third party reaps, then the loss is cast on the third parties to reimburse the same to the trustee. Now we will see other section. We move to the other section 35. Section 35, when a trustee may, without instituting a suit, apply by way of petition to the court for its opinion, advice, direction on any present questions relating to the management or administration of trust property, other than the question of detail, difficulty, or importance not proper in the opinion of the court for summary disposal. Now, simply, when you summarize this section, trustee may apply by way of petition to the court for its opinion or advice of what direction in relation to the management and administration of trust property, not anything else. If it is in relation to the question of details or difficulties or importance, not proper, whatever it is, something difficult matters, then it should go to the summary procedure. Then in the case of petition, a copy of such petition shall be served upon and hearing thereof may be attended by some of the persons interested in the application as the court thinks fit. As the court thinks fit. That's very important. As the court thinks fit. Then we will see subsection 3 and 4 also, trustee, stating in good faith the facts of the such in such petition, acting upon the opinion, advice, direction given by the court, shall be deemed that he have been discharged he has discharged his duty as such trustee, subject matter of the application. That means if the trustee stating that in good faith the facts in the petition and acted upon the opinion given by the court shall be deemed so far as regards to his own responsibility to have been discharged his duty properly. Then subsection 4 is not important at all. That's a cost of every application that may be determined by the court. Then when you see this section 35, section 35 enables a trustee to seek opinion, advice or directions of the court by filing an application for such purpose of any question respecting the management and administration of the trust property. However, question of detail, difficulty, importance, which by reason of their complicated nature would not be fit for summary consideration have been expressly excluded. Therefore, the language of this section indicates that it is an enabling provision and it is a binding on trustee to seek such opinion, advice and direction in every case. The trustee may seek permission of the court to sell the property, but it is in such a case the trustee has to show the necessity for such sale. The words opinion, advice or direction must be read together as the meaning more than guidance. Opinion, advice, directions, etc. given under this section are not an order at all, and disobedience thereof does not involve committal of contempt. While this section provides for the trustee's right to apply to the court for opinion, etc., in the management of the trust property, it embodies at the same time the limitation governing the question to be asked. That is, they should be present and not future or contingent or hypothetical, and also be other than the question of detail, difficulty and importance, not proper in the opinion of the court for summary disposal. It is also clear that under this section the court will not advise the trustees on disputed question of law or fact, but only on undisputed matters of management and administration, such as question of advancement, maintenance, change of investment, compromise, taking proceeding, so forth. In the case of official trustee versus Chachindra, it was stated that under section 30, this is an Indian case, the Indian Supreme Court held that under Indian Trust Act, the similar section is there. It is section 34 under Indian Trust Act. Under section 34, the court would have only given opinion, advice, directions on presented question respecting the management and administration of trust property, not any other matter. The relief rate by the said law did not relate to the management or administration of trust property, but on the other hand, he asked for authority to alter the quantum of the interest given to such beneficiaries by deed of intervenors. The jurisdiction conferred on the court under section 34 of the Indian Trust Act is limited jurisdiction. Under that provision, court has not been conferred with overall jurisdiction in the matters arising under the trust deed. Therefore, what we have seen here now from this judgment, it is limited to administration of management, not anything else. If anything else, then you must go for a general summary procedure. And also, if it is a disputed matter, then go for a summary trial, summary procedure, not for the under this section 34, 35 of the Trust Ordinance, we can't challenge those things. If for an advice or direction in relation to the management or the administration of the trust property, we can ask for any opinion from the court. While dealing with the similar provisions of the law of trust in England, it is observed that the powers of the court in this respect is merely offering guidelines in the execution of trust deed. And that is the true import of the words opinion, advice, and directions. It is observed that the intention of the legislature in this respect is that court should have the power to advise the trustees and executors as to the management and administration of the trust property in the manner which must be advantageous to the parties beneficially interested, but not to decide a question affecting the rights of the party intervened. Therefore, the court under section 35 will not have any jurisdiction to advise the trustee about the disputed point of law or fact, but will do so only as to undisputed matters of management, such as question of advancement, maintenance, change of investment, sale of a house, or sanctioning compromises and other such matters non-disputable or dispute nature. Under section 35 again, a direction is given under this section is not an order in the sense that it is a judgment or decree of the court of law to which the court would demand obedience, and if not obeyed, the party may have the right to execute such direction. So, what court does in this jurisdiction under section 35 is to advise, guide, or direct the trustees as to way in which the trustee should proceed. So, if the trustee refuses to accept the advice or to obey the direction given, he cannot be liable for the contempt of law. But the trustee does it at his own peril, because such failure to obey the direction doing contrary to it may amount to the breach of trust. Now we will move to other slide here. Now in this slide, it's a case decided by Indian Supreme Court in the good of Soki Kumar Kishore AIR 1969 Kolkata report 462. It was held by Kolkata High Court that the use of words directions in this section clearly denotes that what is contemplated therein is not a adjudication and determination of any substantive right, but only giving an advisory opinion by way of guidance to the trustee in respect of practical management or administration of trusts. It is therefore pointed out that under Section 34 of the Indian Trust Act, the court will not act when the question involved is one of the title or the construction of will, or in the matters when complicated questions of law are involved. When the trustees of a deed of settlement deferred in the exercise of discretion conferred upon them, it is proper for the trustees to seek advice of the court in what appropriate manner the trustees should exercise such discretion. When a compromise is sought to be entered into between trustee and the person liable to trust, the sanction of the court becomes necessary, and the court, while deciding whether to accord sanction or not, will not only to take into consideration views of the beneficiaries who are sui juris, but also the infant beneficiaries as well. It is competent for the trustees to seek court's direction to sell trust property. So it is only when extreme necessity arises, then only the court may be approached. Therefore, when the trust properties are deteriorating, then there is no other source from which the properties can be repaired. Then the court may direct the sale of trust property to meet such expense of repair. When the vital matter of importance are involved relating to sale and conversion of trust property, there are certain matters the court's jurisdiction would not be invoked, and proper remedy would be seek such determination by way of regular civil suit. Then we will move to other section here, section 36. Section 13, right to settlement of accounts. When the duties of the trustee as such are completed, he is entitled to have the accounts of his administration of the trust property examined and settled, where nothing is due to the beneficiaries under trust, to an acknowledgment in writing to that effect. Once the trustee completed everything perfectly and get an acknowledgement in writing, everything settled to the beneficiary. Section 36. The scope of section 36 is something to ensure the correct administration of trust property. As we have seen, section 19 of the Trust Ordinance cast a duty upon the trustees to keep clear and accurate accounts of the trust property. And on being asked to do so, he has to furnish the beneficiary with full and accurate accounts. And the section 36 confers a corresponding right to an acquittance corresponding right to an acquittance from the beneficiary that his claim had been settled. It is an essential protection of the trustees against being called upon to answer the question relating to administration of trust by him at a later time. In order to protect the trustee from being harassed with claims by beneficiary at a later time, Section 36 gives the trustees, on completion of his obligation as trustee, a right to have his accounts settled and to receive from the beneficiary that the claims and demands have been settled. Section 36 contemplates that the trustees shall obtain acknowledgment from the beneficiary that all the accounts have been settled, and such acknowledgment received shall be treated as sufficient acquittance of the trustee. Section 36 does not prescribe any form of acquittance, but it must be in writing. It may take any form. However, a receipt given would only a protection in respect of claims. Now we will move to other section, section 37. That is a general section, general authority given to the trustee. In addition to the powers expressly conferred by this ordinance or by the instrument of trust, and subject to the restriction, if any, contained in such instrument and to the provisions of section 17, the trustee may do all acts which are reasonable and proper for realization, protection, benefit of the trust property, and for the protection and support of beneficiary who are not competent to contract. It is well settled that the source of the power of the trustee is the instrument of trust. He has to exercise such powers subject to any restriction put forward in the instrument of trust. The Trust Ordinance contains certain provisions to the trustee subject to duty and liability contained in section 17 of the Trust Ordinance. The primary obligation under section 17 of the Trust Ordinance is that when there are some beneficiaries, then the trustee is bound to be impartial. We always emphasize in this point, under section 17 of the Trust Ordinance, the trustee must be impartial towards beneficiaries and must not exercise or execute the trust for advantage of one at the expenses of another beneficiary. However, in addition to the powers conferred upon the trustees under instrument of trust and by other provisions of section 37, confers upon the trustee a general authority to do all acts which are reasonable and proper for realization, protection, benefit of the trust property, and for the support and protection of the trust property who is not competent to contract. Section 36 appears to confer general power to a trustee, yet when there are more trustees, then the expression trustee under section 36 includes board of trustees. So one trustee cannot deal with trust property to the exclusion of other trustees or board of trustees. Then all must work together and decide together. In the case of trust property requiring repairs, it is within the general authority of the trustees to carry out the repairs, and it is not necessary in every case to seek permission of the court by applying under section 35. These are the incidental power given to the trustee to look after the trust property. When the trustee has trustees have discretionary power of sale, the court will not interfere with such powers to compel the trustee to sell. However, if the trustees act improperly, unreasonably, the court will interpose and stop the sale. Even though the trustee have necessary power to repair the mansion, but it does not extend to the total demolition or reconstruction. But in some cases it may be, but generally if the power given to repair it, then it does not extend to demolish and destroy the things. Then suppose no power to sale. What is the case? In the case of no power to sale, when the trust consisted of a house property and needed urgent repair at a heavy cost, so that it would be prudent for the trustee to sell the properties than to make such extensive repairs in the absence of power of sale. Express or implied conferred in the instrument of trust, trustee must invoke the extraordinary jurisdiction of the court to obtain the permission for sale. Because the instrument of trust, the deed of trust, empowers the trustee to repair. But when you see the cost of repair is heavy cost, then as a prudent man, as we have studied in section 15 of the Trusts Ordinance, we must apply the prudent man theory and must get the opinion of the court and sell it. When the terms of the instrument of trust directed the trustees that the realization from the rent or sale of the property are to be applied. The realization from the rents or sale of the property are to be applied for certain purpose. It is clear that it confers upon the trustees an implied power of sale to meet the expenses for such purpose. But mere direction to divide the property among the members of a class or member of individual would not give rise to a trust for sale. Now we have seen these powers, rights of the beneficiary. Now we have already seen, as I told at the beginning, we have seen the duties and liabilities of the trustees. In these lectures, what we have seen, mainly we have seen right to get the custody of the deed of trust as well as transfer deed under section 32. Under section 33 we have seen right to reimbursement of expenses. Sometimes if the trustee overpaid to the beneficiary, then there's a charge. That's a lien of the interest of the beneficiary. Then we have seen right to indemnity from the gainer of breach of trust. That is, really speaking, a person other than the trustee or transferee in good faith for the consideration who has gained some sort of advantage from the breach of trust. Then the trustee has some sort of right to indemnify from the gainer by the breach of trust. Then in section 16 we have seen right to apply the court for an opinion or advice or direction in the management of the trust property. But it is limited to management or administration of trust property, not to all the matters. That's why clearly the section excluded certain matters like detail, difficulty and importance not proper in the opinion of the court for summary disposal. Those matters must go for summary cases. Then we have seen under section 36 right to settlement of accounts. Once the trust is completed or fulfilled, the purpose is fulfilled, then they must settle the account, they must see everything as we have seen under section 619 also. The trustee is bound to keep proper accounts. And this also, again, this is another way, the right given to the trustee. Once settle everything, trustee has some sort of right to get an acknowledgement from the beneficiary. Then finally we have seen the general authority. In addition to the power expressly given in the ordinance or in the trust deed, and subject to all these restrictions what we have seen, trustee may do all acts whatever reasonable and proper for the realization, protection and benefit of the trust property, and also for the protection and support of a beneficiary who are not competent to contract. Now that is the end of right of the trustees. Thank you.